that I am Harrison Lamont Bay, all lowercase letters. I'm here to tender a special deposit to the court and make the clerk fiduciary.
I don't have time. Harrison Lemon, the second. That's the gentleman with the Fez hat on, headgear on. Can you unmute yourself, please, sir? Is he connected to audio? Lemon Bay, Harrison Lemon Bay. Can you hear me, sir?
Can you hear me?
I can hear you. Good morning to you.
How are you?
Okay. Are you the second or the third?
I'm here on behalf of the third.
The third. Okay. And I guess it's the second as well. This is the city of Detroit versus Harrison Lemon Bay the third. Straight that. This is the state of.
Buckle up, guys. Today we're diving into a courtroom showdown like no other, because this defendant thinks grammar can beat the justice system. He kicks things off by refusing to identify himself in any normal way, instead saying, "I am that, I am," and arguing about capital letters in his name. That's right. He truly believes lowercase letters give him legal immunity. The confusion is instant, and the judge is already fighting to keep order.
Michigan versus Harrison Lemon Bay the third, case number SX 4195968, counts 1 and counts 3. Appearance for the record, please.
Elwood S. Berry Jr., on behalf of the defendant. State your full name, sir.
Your Honor,
Mr. Berry, I think he's representing himself.
Your Honor,
Yeah. Yeah, all right, and add count 3 to that, add count 3 to that record as well. Or count 2 to that, or 1 to that record as well. So count 1, 2, and 3. Let me have that other. I believe, state your name for the record, Mr. Lemon the third.
Yes, I am Harrison Lamont Bay, all lowercase letters. And I'm here on behalf of Harrison Lamont the third.
All right. Well, I've never heard of the all lowercase letters. What does that mean?
It means that the name is to be spelled with all lowercase letters, not all capital letters, not part capital and lowercase.
So today is the date and time set for a pretrial in the matter. How do you want to proceed, sir? I know you filed some documents with the court, and I did have those up in my chambers. But how do you want to proceed?
Your Honor, I'm the surety on behalf of the principal debtor, strawman Harrison Lamont III. I've given the court notice weeks in advance. I'm here to tender a special deposit to the court and make the clerk fiduciary, the prosecutor.
All right, guys. Things spiral fast as the man claims he's appearing on behalf of himself, separating his flesh and blood self from the legal name on file. This is sovereign citizen wordplay at its peak, designed to stall, not solve. The judge, trying to remain calm, asks him to confirm his name multiple times, but instead of clarity, he throws in more riddles, trying to drag the court into his illusion. The tension is rising, and it's only just begun.
As well, and I'm looking for a plea of release today. Will you grant a plea to release?
No. I can grant you a pretrial. I can grant you the opportunity to speak with the city attorney, or I can grant you a trial date by judge or by jury.
Yeah. So
what would you like to do, Mr. Lemon Bay?
Well, do you mind if I ask a couple of questions? Just want to make sure that I'm comprehending it. So, as you gave the name, I heard you mention a few different names. I heard you mention Harrison Lamont Bay the third, and then a Harrison Lamont the second, and various different names. I just want to make sure that I'm clear on who or what it is that we're here to discuss, because I don't want to speak on behalf of
All right. It does have an error. It does have an error. It appears to be an error on the computer here. So entry date, one of the counts was entered into as, one count was entered into as Harris Lemon III. The other count was Harris Lemon II.
Here's where it gets wild. He argues that his name is spelled improperly and says it must appear only in lowercase. Why? Because he thinks capital letters create a corporate identity separate from himself. It sounds like a comedy sketch, but he's dead serious. The judge patiently explains that the court's process is standard, but this guy's focused on typography like it's life or death. You can feel the frustration building with every word.
And the other count was entered Harris III Lemon. So I think that's just a typo. There's the nature of the offenses. There's the misdemeanor case is driving without a valid operator's license, no ops on person, and that is a 93-day punishable by the maximum possible penalty, 93 days in jail and or $500 in fines. And you have two civil infractions, one expired plates and the other one speeding at 16 to 20 miles an hour over the speed limit. So those are the nature of the charges. I'm going to offer you an opportunity to mitigate this by taking the better driver's course, sir. I'm going to put that in the chat if you choose to. And I can give you time to do that. If not, you can set it for a trial date or whatever set it for a trial date or speak with the city attorney today. What would you like to do?
I'm really, again, I'm ultimately I'm here to tender special deposit and settle the charge.
Fines or taking it to trial, see if you can do better at trial. You have a right to a trial by judge or jury, and that's it.
Now the defendant tries a new angle, asking for a plea of release and declaring a special deposit. These are meaningless terms, but to him, they're part of some secret legal language. He's throwing in words like fiduciary to sound official, but the judge isn't playing along. She presents him with three options: talk to the prosecutor, proceed to trial, or resolve the case. Still, he stalls, banking on confusion over compliance.
Those are your only options, sir.
I'm looking for a plea of release. Are you stating that there's no offer of equity in this matter, Your Honor?
I don't know what you're talking about. All right, we're gonna move on. So I don't have time for this.
Would you like to speak to an attorney? Would you like to speak to an attorney, sir?
I don't. I'm not asking for counsel.
Okay. Well, we're gonna pass the matter and we're gonna move on, and he can just watch and see how it works in here, because I have too many people that are waiting that want to be heard and hear their claim, and I don't understand what you're saying. I've given you your options, and you can sit back and ponder those. I'll give you time to ponder those options. Other than that, sir, I don't know what else to tell you. All right, let's move on. Next time. No, I've already answered the questions I'm going to answer. No, please mute your device, and you either take the offers that I've given you, speak with the attorney, or take the deal, or set the matter for a trial date. Those are your options.
At this point, things heat up. The defendant complains about inconsistencies in his name spelling across documents, suggesting it invalidates everything. The court calmly corrects the record and then moves forward, reading his actual charges: no license, expired tags, and speeding. Suddenly, all that wordplay seems meaningless. The court deals in facts, not fantasy, and the gap between the two is growing wider by the second.
Let me set the matter for trial.
Set the matter for trial. Okay, I'm going to give you a trial. I'm going to. Do you want to Trial by judge or jury, sir?
Your Honor, by jury.
Okay, jury trial. Can I get a jury trial date, please? Let's do June the 2nd. June the 2nd. We should do this in the afternoon as well.
Well, we gotta set a pre-trial first.
Yeah, we'll set a pre-trial. So your next court date is gonna be a final pre-trial, sir? Final pre-trial will be June the 1st, 6/1/2023 at 8:30. And then we'll set the jury trial date for the next day at 9:30 on June the 2nd. So your next action date that you need to appear is June the 1st at 8:30. And then the next day we'll have the jury trial at June the 2nd, 2023. I have received your motions. If you have any more motions, make sure they're in before the June the 1st date, and then we'll proceed with picking a jury.
Guys, here comes round 2 of the special deposit nonsense. He repeats it like a magical spell that'll make his charges vanish. But the judge doesn't flinch. She firmly explains that this courtroom operates by law, not illusion. The defendant tries to ask irrelevant questions and derail the process, but the judge keeps steering him back to reality. Pay your fine, talk to a prosecutor, or face a jury. There's no third path made of make-believe. The courtroom reaches its boiling point. The judge offers the defendant a final opportunity to cooperate, but he doubles down on phrases like offers of equity, clearly not understanding or caring how courtrooms function. The judge, tired of the circus, lays out the schedule, pre-trial and trial dates, no more games. She even tells him to sit and watch real proceedings to learn how it actually works. His fantasy just hit a brick wall. All right, guys, in the end, the man finally picks a jury trial. But let's be honest, unless the jury believes in legal fairy tales, he's toast. The judge schedules the case and moves on, having wasted precious time on a performance that never had a chance. It's a masterclass in how sovereign citizen tactics crash and burn under real law. Like the video, subscribe to the channel, and we'll see you in the next video.